It's a great pleasure to have here with us today a human rights expert that really requires no introduction, and somebody who is a big friend, an important friend of the law department, and with whom we've previously collaborated closely in relation to issues pertaining to human rights, UK law concerning human rights, but also international perspectives on human rights, Jonathan Cooper, OBE. Jonathan is one of the leading barristers at leading human rights chambers, barristers chambers, Doughty Street. He is an expert on domestic human rights and international human rights. In fact, he has earned his OBE for his important contributions in this field, including in relation to the implementation of the Human Rights Act. And as you will know or may know, the Human Rights Act is the domestic piece of legislation that brings into the UK, that incorporates into our own law, the European Convention on Human Rights. Jonathan has also done important training and public engagement work, including in relation to training our judges and training our soldiers and training our military concerning human rights standards that they might need to abide with. Jonathan will be joining us now.
Hi there. Very good to be here, and thank you very much for inviting me. And it's a great pleasure to be here with your colleagues at Goldsmiths.
It's wonderful to have you here, Jonathan. And I mean, I'm very much looking forward to discussing with you where we are and where we are heading towards when it comes to COVID-19. There are important questions relating to the actions that the UK government has taken or indeed failed to take to prevent the spread of the disease. We had Keir Starmer just the other day explaining that the UK now has the highest death toll in Europe, the second highest in the world, and that quite obviously something has gone wrong. I think he was pointing the finger quite clearly there to some important omissions from the part of the government. So I'd be very keen to hear your analysis on that as a starting point in our conversation.
You raise a very, very interesting and important points, Dimitrios, about the role that law will play in this. And one thing we can guarantee is that this coronavirus crisis will dominate legal systems for years, if not decades to come. And we can anticipate, and we should anticipate, that actually the story of COVID-19 will be told through those cases, and we'll get a much richer and a much better understanding of what's happened or what failure to do and to act through the cases that that will be brought. And it's quite an interesting way to look at it. So you've got the sort of extremes on the one hand of kind of some people are suggesting international criminal law may get involved with crimes against humanity. I'm a little skeptical about that, but it's something I certainly think we should put it on for some academic discussion to put it on the table. So on one extreme, you've got the prospect of international crimes against humanity. And then on the other extreme, I think you've got the work of the ombuds system. And I think we will definitely see the ombuds system in this country and across the world where there are ombudsmen, that those systems will be caught up in questions around maladministration, around the crisis that we're going through. And then sort of there in the middle will be, of course, human rights and constitutional law arguments. There will be domestic criminal law arguments. I'm sure they will raise their heads as well. And there'll be issues around tort and breaches of contract and other sorts of failures. And there'll be a big question about truth in all of this from a kind of that big idea of human rights really get vindicated through truth, mechanisms of truth and accountability. But if we just focus on the human rights aspects, we will inevitably see, and it won't just be in this country, but inevitably things have gone wrong in this country, and therefore people will have genuine grievances and people will be in mourning, and they will want to understand what's happened and why it's happened. And so the right to life will obviously play a big part in that. And the right to life has many aspects to it, but the key obligation in relation to the right to life is the obligation to protect life. And a state must do all it can to protect life. Where there is a real threat to life, the state has to do what it can do to ensure that life is protected. And so if you look at that from a UK point of view, and the UK came quite late to the epidemic, to the first cases of coronavirus, but yet we were one of the last countries to introduce strict lockdown measures, and even then the lockdown measures weren't that strict. They've been much stricter in other countries, as I'm sure you're aware. And so there will be questions, therefore, that arise that was the right to life adequately protected under the circumstances? I mean, it is interesting if you compare the New Zealand response. I appreciate New Zealand's a much smaller population than the United Kingdom, but the New Zealand response, they went in quickly, they went in hard, and they really have managed to control the crisis in New Zealand very effectively, which obviously on one level means they're coming out of it all very much quicker than the UK will. But more importantly, the impact on the daily lives of New Zealanders has been significantly less. And so the question then becomes, and this will become a factual issue, what did the government know? Why did the government take the course of action that it took? Why did they not prioritize the right to life and seemingly prioritize other approaches to living or dying with the pandemic? And central to this whole debate is the sort of the legal, but also probably more philosophical discussion around human dignity, and the idea that human dignity is that essential right that we all benefit from, which recognizes the humanity in all of us and recognizes that we are all of equal value, and therefore we don't prioritize one group of people over another group of people, and that everyone's worth is equal. And
I wanted to ask you about Jonathan. You have written in the Times that the government's omissions, the delay in triggering a response, a substantial and informed response to COVID-19, was not just an illustration of an unfit government, but also a demonstration that the government was unable to comprehend the importance of the right to human dignity. Like to elaborate on that?
Well, I think it was that they chose not to prioritize it. And so I think if you compare the response again, say, to the New Zealand government, to the United Kingdom's government, or the German government or other jurisdictions, which put dignity first, they became, the evidence was clear to all of us, and those jurisdictions went into lockdown very early on, because the only way to ensure people were not, the human dignity was not violated, was to not expose them to the virus. And there was no other way to deal with it, in much the same way as the right to life discussions will be had. The only way in which to protect life is to avoid people's exposure to the virus. But the dignity arguments are different than the right to life arguments. And it's that idea that there was that suggestion that the government allowed to kind of filter through into society, that somehow it was okay to permit a certain number of deaths, if that meant that somehow there could be some sort of immunity that I mean, it's very unclear whether that argument has been put forward later or earlier. It's unsure, but they certainly were taking what would be probably correct to say a more utilitarian approach, i.e., trying to measure what's in everyone's, in the interest of the majority, and obviously utilitarianism and human dignity. I mean, they may coincide, but human dignity can't really countenance that notion that somehow there's an acceptable number of deaths, because human dignity can't kind of accept or countenance the idea that you would instrumentalize a human life, or that you would somehow objectify a human life, therefore removing from it its core essential humanity, and therefore somehow accepting that, well, if the economy will continue to thrive and 10,000 people die, somehow that's okay. Dignity can't do that kind of computation. Dignity says your obligation is to recognize the human of everyone. Yeah.
And the government has gone back and forth about whether it was actually adopting that policy. I mean, we have learned that one of the primary advisors to the Prime Minister, Dominic Cummings, has expressed a quite strong view about the utilitarian ethos that you were just elaborating upon, to the effect that protect the economy, and if a few thousand pensioners die, so be it. That's the point that he made. And I mean, it's quite hard to know the science, the exact science here. I mean, you're not an epidemiologist, and I'm not one either. However, having said that, what I found quite striking in this debate is that the UK was pretty much in isolation in adopting this kind of mentality, this utilitarian ethos that was justifying, even in the context of this wider discussion that we were having, even if it was not necessarily incorporated into formal legal policy, it was sort of justifying this idea that at the end of the day, we need to protect the economy. And if that means that a few thousand people die, that's fine. That's acceptable. That is an output of that mathematical calculation that we can accept. I mean, I found that quite intimidating. I found that quite terrifying, and I found quite striking the fact that we again, in Britain, in the context of another important conversation, we were completely out of tune with what was happening in other parts of Europe.
And there is other considerations here that, there is a government that has started the year off with one goal, one driving ambition, which is of course Brexit, and therefore nothing was going to derail it. And also a vision for Brexit, which was about a unregulated free market for the United Kingdom. And the Prime Minister, of course, and I'm sure he will regret his words now, but I think it's the 3rd of February when he makes his speech in Greenwich, not far from where you must be sitting now at Goldsmiths, if you're in Goldsmiths, where he is setting out his vision for Brexit, and he makes reference to the coronavirus and the fact that some economies may close down in the context of that virus, and he says that he will himself personally enter into the phone box and re-emerge as the sort of Superman superhero, and battle away to ensure that the free market of the British economy, liberated from the European Union, functions. And so he's already exposed himself to what they consider to be important. And if you look at what was being said at the time in Germany and in France and in Italy about the need to protect the dignity of others and the dignity of everyone, it's absolutely contrary to that. And so it's quite a curious thing when that tens of thousands will die and are infected, that you would somehow assume the role as Superman to defend the economy as opposed to defend people from the miserable deaths that they will have continue to experience, and the grief that families have been exposed to.
And I would say if one reads widely and if one looks at different sources, so if you take if you read what is currently being discussed in the Telegraph, for instance, it is as if the impact of the thousands of deaths that we're currently experiencing is not being felt at all. It is as if it's not happening. I mean it in the way that the whole conversation is about the unreasonableness of the lockdown, and to the extent that they seem to be insinuating that we shouldn't have had the lockdown at all. And in recent days, I've been reading quite a lot about how Sweden is suddenly, a model country. But Sweden is a very different country, I think. It's not as, and it's not as if they have not had a substantial number of victims there. My concern is that again, the right to life, the right to health seems to come second in this balancing that is happening, where the economic priorities of some seem to be coming first.
And it is an extraordinary, there's that extraordinary lack of sort of empathy that people don't seem to understand because they may not personally be being directly affected, that they're incapable of empathizing with the thousands that have been devastated by it because of deaths, and those that have gone through it and gone through it very badly. And it's a bit, if you're comparing these things, I think it does help to compare. I've also written up comparing what's going on with the AIDS crisis back in the 80s and 90s. And again, then it was people that weren't clearly, the AIDS crisis affected a particular group of people. It principally affected gay men, and therefore people that weren't directly affected, they somehow felt there was nothing to do with them. They felt they may have sympathy, they may not, but they certainly have no empathy, and so they allowed that crisis to sort of continue in a way that is, when you look back on it, it is shocking. I mean, the UK got away relatively lightly. 10,000 people died until the epidemic was brought under control, or that crisis was brought under control. And it's interesting when you look at that, the fact that people are able to say, well, it doesn't really affect me, it only affects older people, or it only affects, now we're going to start, laying into to bigger people, obese people. It doesn't, that othering is a real problem, and that othering again undermines human dignity. And so if we put the human dignity debate up front, we put the right to human dignity up front, and that was the basic building block upon which we build our public policy, we come up with very, very different results. You just go back to New Zealand again to have that discussion. They've had a very, very different pandemic because human dignity came first.
You pointed out how this is a process of othering, of excluding the other, of alienating those that are not necessarily part of the dominant majority, or the majority with dominant interests, including economic interests. And what also springs to mind here, you spoke about the parallels with AIDS, but I also know that you've drawn some significant parallels with the Windrush scandal. It was all about othering. It was all about excluding and isolating and being indifferent about the situation of others. I mean, that conversation is also very pertinent to the community of people that are close to our heart at Goldsmiths, and that part of London in particular. But I think that there are very important similarities there with the winter scandal on the one hand, the reaction to COVID-19 on the other, and also perhaps a third factor or another area with which we can draw parallels is the conversation that we've had in recent years. And again, that is a conversation that I was particularly intrigued about and interested in and passionately engaging with, the situation of EU citizens in the UK as a result of Brexit. And there, again, we saw that the majority didn't care enough or was completely oblivious, I'd say, about the interests of 3.5 million people were affected by the decision to withdraw from the European Union. And yet everybody seemed to be pretty much fine with the fact that the rights of 3.5 million people were actually going to be a bargaining chip in the negotiations. And it took 2 years. It took 2 years for Theresa May's government to begin to acknowledge that this was an area of concern. And I'm not even convinced, not to this day, that had happened, that would have happened had it not been for, I think, quite crucial intervention from the part of the EU, which said, this is a key part of the negotiations. And until and unless we have resolved that, we can continue with potential discussion of the future relationship with the EU.
Well, if you look at the evolution of human rights in the United Kingdom and how they have come about, we've never done that, again, to be philosophical about it, that sort of Kantian concept. We've never gone through that process of saying, actually, the British state, the UK state is all about recognizing the dignity of others. And then if you compare that with then, say, for example, Germany being the obvious case at hand, where human dignity is the first article of the German basic law, or the German constitution, you see what a difference it makes. And I think it is a problem for the United Kingdom, that somehow the recognition of dignity cannot be taken for granted in government, whether central or local. And that is a problem, and it really should be the principal priority of all government, of all of us, but principally government, to recognize the human dignity of others. So, I mean, COVID-19, this crisis has thrown up this very stark problem that the United Kingdom does have to consider and address. And we do need to be asking ourselves, we as a community and a society need to be asking ourselves, what kind of society are we? But we also need to be saying, is our framework, our small c, big C constitutional framework, adequate to create the kind of people we are and want to be? And I say there is something very much lacking. And it's almost the problem around UK human rights is that we've always sort of done it so apologetically. We've sort of, arguably the problem with the Human Rights Act is, we get our rights in the Human Rights Act, from a subsection to a section of an Act of Parliament, and they're scheduled to the back of the Act. And if you compare it to, what I just said about the German Basic Law, or France, or Greece, or Italy, their framework for the United States, their framework for human rights protection is really the core essence of what it means to be from France, Germany, the United States. The Bill of Rights in the United States is, this hallowed, sacred document. Whereas the United Kingdom, we got our rights in a subsection to a section of an Act of Parliament, and somewhere in the back of the Act, if you're lucky, you'll find them. In the schedule.
I couldn't agree more, and I think it's wonderful to express that strong faith in law, in constitutional law, in constitutional human rights, in international human rights more broadly, as a source of protection. When it comes to fundamental rights, without the right to life, or to the right to bodily integrity, the right to health, the right to human dignity. As you rightly point out here, Jonathan, But I think there's also a less optimistic perspective here. And you mentioned the example of the United States. And of course, there is a very rich culture of constitutional human rights that stem from the American Bill of Rights there. And yet, they haven't been capable of stopping the lunacy coming out of the political situation that is currently defining what the US is. I am sure that in the end, in middle term, long term, the US Constitution will provide safeguards and will protect individuals. But unfortunately, to put it more simply, to put it more bluntly, Trump, there was a sort of a tsunami that devastated logic, law, human rights when passing through the country in the current environment. And I'm afraid that it's equally worrying that there are some parallels there, again, to be drawn between the UK and the US vis-a-vis the methods but not just the methods, but more importantly, potentially the narrative that has been so central to the reaction to COVID-19, or the lack to react to COVID-19 as early, as promptly as these two countries should have.
And I think the litigation that flows, again, will end up telling the story of the pandemic in both the United Kingdom and the United States. I mean, inevitably there'll be a public inquiry, certainly in this jurisdiction, but I think the litigation will be as key to telling the story of what happened as as the public inquiry and that kind of pursuit of truth in it all. But I think what happened, at the beginning of the year, when we knew this virus was coming, and the British government had different priorities, the Prime Minister had different priorities, a lot of which were being on holiday. But it's very, very interesting. If I was going to be very controversial, and will expect a large amount of hate mail for what I'm about to say, it's interesting if you compare Johnson with Blair, because Blair almost was overly protective about the security of the United Kingdom and of the British people. And he went to extremes, arguably, to protect the security or maintain the security, and got into all sorts of, people say, if you go back to the millennium bug, nothing happened. Why do we have to go through all this agony for it? And obviously his point was, we went through the agony, so therefore nothing happened. But if you look at, foot and mouth as well, and the response to that, people were saying, oh, this is overkill, literally overkill. But his government got all of that under control. And you compare the UK government response to, or his government's response to foot and mouth with the response of the previous administration, the John Major's administration, in relation to BSE and the mad cow disease, and you see two completely different approaches. And one, the Blair approach, which puts security first, security and arguably dignity first, really does not permit any risks to the security or the dignity of the United Kingdom. I mean, obviously he then goes too far in the context of the Iraq War, and show that in itself shows that you need to have checks and safeguards in place to stop these people going too far. But his motivation for the Iraq War, I have no doubt, was purely driven by an overblown security concern for the UK. But so that's another example of this idea that it's too, our dignity and security. What's that saying about equity? It's the length of the Chancellor's foot or something, or some old common law saying, which I've never fully understood. But the idea that it could be literally dependent upon who is in office. But I think, going back to the point about this will all come out in litigation, in human rights litigation. It won't just be the right to life. It'll be arbitrary detention. We know people have been being detained. It turns out these laws, regulations that were rushed through, in the Coronavirus Act weren't probably necessary in the first place, but maybe weren't precise enough, and so all of that policing is going to be brought under review. We know already that there's big questions around privacy and government responses, and this NHS app that we're all to download. And it's quite interesting that they haven't taken the opportunity that human rights offer. Human rights offers a real solution-driven approach to all of these. So you want to make sure that privacy is protected as you develop this technology around tracing and those who've been tested or appear to have the virus. The same around the policing of the lockdown, and obviously around right to life and other sort of fair trial issues. And ultimately, I think one of the problems that they made at the very beginning was not derogating. I am definitely in the camp of people that think derogation is a good idea, because you then say there's an emergency threatening the life of the nation, we must derogate. That act of derogation then puts the derogation and the derogating powers under review, and therefore you're given a process. You lift the derogation when it's appropriate to do so. And I think the government's decision to sort of ignore the human rights implications, even though I don't think they necessarily did violate them, I still think they should have derogated, because we are in an emergency threatening the life of the nation, and it's absolutely appropriate to say we may have to adopt different measures. I mean, and even in the future, I mean, we seem to be coming out, in my view, of the lockdown too soon. That suggests there'll be a second wave. To control that second wave, they may have to adopt more and more increasingly draconian legislation. And then, the fascinating question, again, from a public health, human rights perspective, is should we be considering criminalizing the transmission of COVID-19? And therefore, and again, if you go back to the AIDS crisis, where criminalization is wholly inappropriate, because obviously it's can only outside of force, it's choice, you're making a choice. Whereas if you go out with COVID-19 and you're pretty sure you've got symptoms, but you still go out, risking the health of all those you come across, should that be a crime?
I think that raises a number of interesting issues concerning intent. The mens rea element in crime. Do you have intent? Sure. Intent. Are you reckless? Issues that the students would expect to be confronted with, and intrigued about if. They join us or they join a law program, they would be studying these elements as part of substantive criminal law. And then you mentioned policing, and again, the students would be studying these topics in criminal justice modules. And at Goldsmiths, there is this program, which I think is quite unique in the sense that it brings together two areas where there's significant focus on protecting individuals, the need to protect individuals. Criminal law, criminal justice on the one hand, human rights on the other. So it's the LLB law with criminal justice and human rights. And it exposes students to how our criminal justice system operates, the limits of criminal law on the one hand, and then human rights as a barrier to extreme criminalization, for instance, or as a factor that helps the government, should help the government define the limits of criminalization. Just to take a couple of illustrations, or human rights as a method that helps us determine how far should policing go. And we know that we have significant concerns. I mean, Jonathan Sampson perhaps went a bit too far, but still he spoke about the UK turning into a police state unless we're very careful with the implementation of the COVID-19 legislation. And I think in a way he was right to observe that there are significant risks here.
But that's why if you derogated, so if there was a derogation in place, by definition, everything is time limited. everything will be reviewed. If nothing else, it'll be reviewed by the Council of Europe or the UN and the European Court of Human Rights ultimately. And so you built in that ultimate safeguard that, you know, and international human rights law makes it clear that a derogation is a perfectly human rights compliant thing to do, and you derogate in order to restore the human rights that have been limited by the crisis, and that the state has also had to further limit to get the crisis under control. And I think it gives you a framework for those of us who want to regain our rights and to, you know, put human rights, enhance our human rights arguably after this crisis. It gives us a framework in which to kind of ensure that we go at least back to where we were, if not adding to human rights protection, you know, after the crisis. So I definitely see the value and the merits, the benefits of derogation, and it's a very interesting subject for. I don't know if any of your students will be thinking about doing PhDs, or it's a very interesting area of study. And the opportunities
an area in which we have seen significant variation across the Council of Europe, with different contracting parties adopting quite varied positions on that. Jonathan, I'm mindful of time, but I would like to, I mean, you have exposed students to very rich scholarship, the jurisprudence of human rights applied to a very serious situation, you know, to a global pandemic that is affecting our ability to enjoy fundamental human rights, be that the right to privacy or the right to fair trial, or more importantly, even more importantly, the right to life. And so I'd like us perhaps to try to conclude with some consideration of you know, what all this means for people, for students who want to go into the study of law. You know, what it means for them that we find ourselves in this situation, trying to tackle a global pandemic, you know, dealing with a watershed moment as Brexit, for instance. What important opportunities are created for the future legal practitioners as a result of this phenomena?
Well, without question, one group of people who will continue to have an awful lot of work post the pandemic will be lawyers. There will be so much litigation that is thrown up by this on the kind of big corporate scale, down to what we've already been discussing around policing, to local governments, maladministration. It's going to kind of inform our casework for years, if not decades to come. And so I think there are all sorts of opportunities here. I mean, it's interesting, if we get treatment very quickly, we learn how to control the consequences of the virus very quickly, i.e. this year, then the impact will be lesser, and we'll get back to normal sooner. But I think there are really, really interesting opportunities. And so for your students that are interested in contract law, you know, how interesting this is going to be for them, you know, when these contracts have been broken, whether it's just about going on holiday or, you know, major transnational deals. That's going to be fascinating. The tort law, the negligence issues, fascinating. The obvious one is public law and human rights. And if we get into the scheme of criminal law, and we're already in it because new offences have been created, but if you get into that situation whereby, and I wouldn't be surprised if they look at criminalisation of transmission as being one mechanism of controlling the virus and controlling how we interact with each other. Because if you're going to take away the lockdown, where we all assume responsibility for ourselves by staying at home, then how do you engage people's responsibility? Well, one straightforward way is to criminalize those that transmit it. Then anyone who thinks they might have it will not go out. I mean, because they'll be at risk of being prosecuted. And so there's so many opportunities here. I mean, opportunities is not the right word, but it's opened up an incredibly interesting way of looking at the law and what law does and what law offers, as well as governments and politics. And, you know, for your students that are thinking, what do they do next? You know, going and working for the Department of Health and being a lawyer at the Department of Health would be a really great job, a really great job.
I think from an equally broad perspective, the global phenomena, the global crisis that we've had to deal with our societies in the last few years. I mean, take the 2008 financial crisis that was followed up by significant crisis within the European Union, with the risk of Brexit, for instance, for a long time, haunting that particular part of Europe and the EU itself. Then it was Brexit. And now the global pandemic, just to take a few, quite gloomy illustrations. But what these have done, they have shed new light on the ubiquity of law, on the importance of law, for better or worse. Law is there, law provides protection, law provides potential solutions to these global worries, to these global problems.
I 100% agree. And the other thing I would like to just say before we close is that I think one of the potential curious good things to come out of all of this is, as inevitably the government is challenged around the Human Rights Act and the rights contained in the Human Rights Act, that may mean, or that should mean, that the government is then less likely to try to dismantle the Human Rights Act and the European Convention on Human Rights. Because one, it is that convention that's provided the narrative for the crisis that we're in. But I think it would be a very brazen government, which probably we have anyway, but it would be a very brazen government that would then say, well, these are the laws that are holding us to account for this crisis, and they are holding us to account, and we're being found to have violated various rights. Therefore, we're going to remove the legal framework that held us to account. I think even for the most audacious of leaders, that's probably one step too far. So I think, optimistically, to end on an optimistic note, it may mean that for the short term, the short to medium term, the Human Rights Act is safe and secure. And obviously, the longer we have the Act, the less likely it becomes that it will be realistic to consider somehow repealing it. You know, for most of the students that will be listening or watching this or involved in this broadcast, they don't know life without the Human Rights Act, and they know that it has made life better or good to the extent that the laws can do that. Whereas, and so I think an irony of all of this, and an irony of the way in which the government will be held to account because of the way in which they've approached it, could mean or will mean that the Human Rights Act itself is protected.
I think that's a very important observation, and we will have to watch this space. But I would say, in conclusion, as far as the Human Rights Act is concerned, that the approach that the Conservative Party or the Eurosceptic part of that party has taken in recent years does not put the UK in a good light as far as the international human rights community is concerned. And so students that might be joining this program, students that might be joining the specialist pathway on the criminal justice and human rights, more particularly, they will have the opportunity to not only learn about these critical issues, but also actively engage with them. So the Knowing Our Rights program, for instance, the Knowing Our Rights project, which is integrated into the degree, and gives the human rights law module in year 3 its key focus, including in informing the relevant clinica there, means that the students will go out and engage with the local community and be part of visits to schools, and will help with the undertaking of school workshops, and will contribute in a vital way to raising awareness about these key areas of concern as we move forward and continue to reflect on the impact that such global phenomena have on life in the UK and the impact that they have on our fundamental human rights. Jonathan, with this, I would like to express my gratitude for your continued support to the program and your wonderful contributions, your insights, your reflections on where we are and where we're going to with COVID-19. I mean, we all hope that it will go away sooner rather than later. But on the other hand, we have to make sure that the government is held to account, and those with decision-making powers are held to account in order to protect life, in order to protect bodily integrity, in order to protect our fundamental human rights.
I agree.